I just have to also kick off by saying, please may you just give us an update on some of the guidelines that are in place and the restrictions that employers have to keep in mind.
So with the Alert Level 1 lockdown regulations, Alert Level 1 regulations were issued on the 21st of September 2020, and it came into effect on that date. It does still read into the earlier regulations, such as obligations on employers, owners of premises and buildings to ensure the mandatory wearing of masks, relevant social distancing protocols, as well as the availability of sanitizers, screening and other relevant PPE. So those regulations still are read with the new Alert Level 1 regulations that have been issued, but many more obligations placed on employers to ensure the safety of all the employees and persons that enter their premises.
But how about sick leave? Where does sick leave play a part here? What if an employee has run out of sick leave days? Are they still entitled to those days if they test positive for COVID-19?
So most of your viewers might be aware that they are already entitled to sick leave in terms of the Basic Conditions of Employment Act, but you have a limit of the number of days of sick leave that you can take. It's capped at 30 days for a 3-year period. But in the circumstances, like you suggested now, where an employee falls ill due to COVID, and potentially also due to the transmission of the virus at the workplace, and where their sick leave entitlement has been exhausted, the employer must make application for an illness benefit that has been provided for in terms of these regulations that have been issued, as well as to ensure that the employee is able to claim from the relevant relief funds, such as the TERS fund, which was implemented sometime earlier in the lockdown.
Wow, it seems like we do have options here when it comes to the sick leave and sick days. But how about UIF payments? And a lot of people right now find themselves fundless. They are not receiving that income and that salary as they used to. However, they're still employed. So are these employees entitled to claim from UIF, or are there other funds available?
The last notification issued by the UIF as well as the Department of Labour indicated that the TERS Relief Fund would be available until 15 October 2020. So there are still processes that are available to employees to claim their benefits whilst they have been affected by COVID. I think COVID has had disastrous impacts on many organizations and to all employees who were not able to work or where they have received reduced salaries as a result of the closures. So there is the UIF fund that is available, as well as the TERS, and I think government will also issue notices as and when there are any extensions, hopefully, of the TERS fund that is available to the employees.
Absolutely. If we were to take this conversation a step further, and we have employees that are maybe in a situation where they're not fully back in the workplace and they're not receiving an income for that, are they then able to go seek other employment while still being employed at the first employer?
Nothing prohibits employees from seeking new employment, and especially in circumstances that many face themselves with, they are without income, and they are entitled to look for better opportunities and a stable flow of income. However, whilst you are seeking new employment, there may be restrictions on your current contract of employment that permits you to work for two employers, two separate employers at the same time. So if you've gone out and sought new employment and you were successful in which to obtain new employment, then you should resign from your current employer, dealing with the necessary notice periods that you might be obliged to give. And in circumstances, if you haven't been paid, you could also try and negotiate that you're not required to work the notice period, if that means you would still not receive an income for that period. So you can seek employment, but there may be restrictions with taking on two positions at the same time.
If people are allowed to go back into the workspace, back into the offices and their office buildings, first of all, are you allowed to say to your employer, I don't feel comfortable going back to work, and especially for vulnerable employees?
So specific provision, if I can start there, specific provision has been made in respect of vulnerable employees.
Okay.
And these employees are persons that are over the age of 60 or may suffer from one or other chronic illness that puts them at a higher risk if they are contracted with the COVID-19 virus. So special provisions are made where employers must take steps to accommodate those vulnerable employees, such as the option to work remotely. However, there are some organizations that are not able to provide the necessary resources to allow persons to work from home. So you can set up an isolated office in which the employee may work. So there are various means in which you can accommodate the vulnerable employees.
Okay.
In circumstances where an employee does not feel safe and if they feel that their health is at risk or sufficient health and safety steps are not being implemented by the organization, they can request that they continue working from home remotely or indicate that they would need to isolate if they have identified any symptoms. Very importantly, what the directions issued by the Minister of Labour indicates that no employee may be discriminated against on the basis of testing positive for COVID-19. So an employer is required to take the necessary steps to protect all employees. It's an obligation not just in terms of the regulations issued by government, but also in terms of the Occupational Health and Safety Act.
What about the finances? If people have taken pay cuts, how long can they accept that pay cut? And what about asking for a raise? Are we allowed to ask for a raise during this time?
So on the pay cuts, it's important to note that your remuneration is a material term and condition of your employment. It's a term that you and your employer have agreed to. If there are any changes to that remuneration, such as a reduction in pay as a result of COVID-19, then that must be reduced in writing and agreed by both parties. So an employer cannot unilaterally implement a salary cut to employees. That firstly must be agreed to, and more importantly, the period for the salary reduction should also be set out clearly in that agreement. So the period and the amount of the reduction must be agreed to between employer and employee. And of course, it would not be too opportunistic to say to your employer that I've suffered the financial burden due to COVID and closures. Are we performing? Are we in a position where it is viable to offer increases? But also bearing in mind that in most organizations, increases are discretionary and it would depend on the financial suitability of the company at the stage.
Wow, that is a mouthful, but something that is so crucial, South Africa. Please do head over to our social media platforms. Use that hashtag Afternoon Express if you've got any more questions or if you want to share your experiences going back to work under lockdown level 1. Samiksha, thank you so much for stopping by and giving us everything we need to know when it comes to employment law. Thank you.
Thank you very much.